It's a medical malpractice case. Trial is coming up, and now I've identified who the defense is bringing in as their medical expert. I do my research and I learn that the defense's medical expert has written a textbook, or at least a portion of the textbook. And I go through every single page, every single thing that this doctor has written, and I find something that contradicts what I know he's going to be coming in and testifying about. Can I use the doctor's own words, his own writings, to contradict him at the time of trial? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, I can use the doctor's own writings to cross-examine him at trial. Now, you might be asking, why would I want to do that? One of my goals when I get up to cross-examine a medical expert is to show that they are being less than truthful. One of my goals is to show that they may be lying. One of my goals is to show that they may have said something in another case in a similar circumstance about the medicine that is different from what they are saying now in our case. And I may have a transcript from another trial that has his testimony. And now I can use that to cross-examine the doctor to show that what he said then is different than what he said now. And now the jury is going to see the two different versions of what he said, and they'll have to reconcile in their own minds whether or not this doctor is still credible. So now, when I'm cross-examining this doctor, I will pull out this textbook and say, "Doctor, are you familiar with this textbook?" "Yes, I am." "In fact, you wrote a portion of this textbook. Isn't that true?" "Yes." "In fact, you edited a portion of this textbook. Isn't that true?" "Yes." "Is this authoritative, doctor?" And you would expect that he's going to say, "Of course it's authoritative." Well, guess what? 99 times out of 100, the doctor's going to turn around and say, "No, that's not authoritative." And you're going to do one of these double takes like, "What did you just say? Did you say that your own writing is not authoritative?" Now, that puts him in a bit of a conundrum. It's a bit of a puzzle. And the jury's going to be thinking, "I don't understand. He's an expert. He's coming in with all these years of experience. He wrote this textbook, or part of it. And now I'm asking him a question about whether this writing is authoritative." And you know what he's going to say? He's going to say, "No writing is authoritative." Or, "It was authoritative at the time he wrote it, but it's been years since then. And there have been many advances or changes in the medicine since that time." Well, doctor, we're talking about this date and time, 2015. At that time, would you agree that this was the standard of care? Yes, it was. And doctor, this patient's problem occurred in 2015, correct? So we're applying the standards that were good in 2015. Now, would you agree that in 2015, this was the standard of care and this is authoritative? And now the doctor's going to get all tangled up in whether or not this is authoritative and whether or not it forms the standard of care, because the moment the doctor says that something that is written in a textbook is authoritative, now I can go to that document, I can go to that textbook, and now I can read certain portions of it. And now I can contrast what is written in here with what he's just testified about. And in all likelihood, they're going to be conflicting. And then later on, after the doctor finishes, at the time I make my closing remarks, I can now show and explain to the jury why this doctor is being less than truthful, or that he has no credibility anymore because he's talking out of both sides of his mouth. Can I ask him whether his own writing is authoritative? The answer is yes, I can. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what happens in a medical malpractice case at trial here in New York. You know, I recognize and I understand you're watching this video because you do have questions and concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit because you still have questions that need answers, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.